Good afternoon. Today is Monday, September the 22nd. My name is Roxana Gamusio. I am the Executive Director with the Tennessee Athletic Commission. This meeting has been rescheduled from September the 8th, so thank you members for being able to quickly move your schedules and make sure we had quorum for today's meeting. As first order of business, I am going to do roll call to make sure that we have quorum. Members, if you can unmute yourself when we get to you, then we will be able to proceed. Mr. Ricky Goodrich. Thank you. Ben Grove.
Here.
Thank you. Corey Cipolla.
Here.
Corey, thank you. We are starting promptly at 2 o'clock. As first order of business, I would like to note that the agenda was posted on the board's website with the change from September 8th through today. That update has been on the website for a full week, almost two. The regularly scheduled plan for this meeting was put on the website on June 17th of 2024, and so proper notice has been given. Quick update to the members. Dan McGrew is no longer on the commission. His term had expired. We do have a new appointment, Mr. Brian Quingley. He was going to join us today and something came up, so I know he's looking forward to meeting and working with the commission here soon. Any items that members from the public have to discuss, whether they're participating through Teams or here in person, we will make sure to leave plenty of time at the end of the meeting under our new business, and everyone's allowed 3 minutes if they've got any questions regarding the agenda or anything presented. As first order of business, we need to approve the agenda. You've got that on your iPads, and it was also emailed to you. If you have any changes to it, please let me know. Otherwise, we would entertain a motion.
I'll make a motion to accept the agenda.
Thank you, Ben. Do we have a second?
I'll second it.
Thank you, Corey. We have a motion by Ben, a second by Carrie. All in favor of approving the agenda, please say aye.
Aye.
Any opposed? Hearing none. Thank you, members. We have also on your iPads the June 9th meeting minutes. If there are any changes that I've missed, please let me know and we can make those corrections. Otherwise, I would need a motion to accept the minutes as presented.
I'll make the motion to accept.
Thank you. We have a motion by Ben and a second by Ricky. All in favor, please say aye.
Aye.
Any opposed? Hearing none. You have on your iPads on page 7 of the 23 pages the final numbers for fiscal year 2024, 2025. This is the comparison of 4 years, which is a good document to review. The commission ended with a deficit of $26,870. It has left our reserve at $69,401. We had several events that we had hoped would bring the commission more money, and they did not in this fiscal year. The next year that's just started should be at a better place, but those are our final numbers. Any questions regarding the financials? Okay. I will turn it over to our attorney, Jesse Gentry, to go over the legal report that starts on page 8.
All right, good afternoon. We only have one case on the legal report today, and it is a case that actually was represented. It was one that the commission has previously considered. It's case 2023058-101. I'll give a quick summary of the original facts, and then there's some new information. But this was a complaint that was opened by a promoter. They filed it against a combatant after he failed to show up to an event. We had filed this for charges to be heard before the commission, as this combatant had not been in communication with us to settle this matter. And then based on the new information, there's a summary listed there, but we have attempted to serve this combatant with the charges to set this for a formal hearing and have been unable to do so. He resides out of state. I contacted the other state's athletic commission where he resides. They didn't have any new information. He did participate in one bout after ours back from 2023. The information they provided didn't give us any new contact information. So at this time, since we haven't been able to serve him, he has not come back to the state of Tennessee to fight in any bouts. I would recommend closing the complaint with a letter of warning, and we can flag his license in case he tries to come back to the state. I have also attempted to get more information from the promoter who filed the complaint. She hasn't been cooperative with giving that information. I think she may be just letting this one go at this point.
What does flagging mean exactly?
So essentially, if he applied to renew his combatant license, his file would have a flag on it. So when the staff is looking at that to approve it, they wouldn't be able to approve it automatically. They would have to go back and look to see what the issue is. So typically when we flag because there's a complaint, our staff contacts legal, we talk about it. With this type of a situation, we probably want to just see what's going on and try to get some more information from him to see if, maybe there was a reason why he didn't show up. He never gave a response when this promoter filed the complaint against him, never gave an explanation as to why he didn't show up to the bout. So we could still approve him for a bout in the future, but I think we just want to get some more information before proceeding.
Yeah, from the information we have, he allegedly took money from the promoter, right?
Right.
And then never paid it back.
Correct.
So, yeah, I wouldn't mind that one coming in front of us too for
Okay.
explanation.
And we could make sure to not approve that until afterwards, or his license until afterwards. But he is, at this point, his license will expire October 30th of this year, so in about a month.
So he still has a license, that fighter?
For another month, yes.
So if he tries to do a fight, it'll get flagged, or only when he tries to renew it?
We can put the flag on immediately. So if he did try to, for example, if someone submitted a request for having a fight later this month or next month, that way we could at least catch it with that flag.
Yeah, I don't think he should fight in the state of Tennessee until he talks to us.
But he would need to do a renewal at least, after October. So we can put that flag on immediately. I haven't seen anything where he's submitted anything to the commission since this complaint since he was approved back in 2023.
Sounds good.
So if you all are good with that recommendation, we just need a vote on to accept that recommendation.
Yeah, I'll make a motion to accept council's recommendation.
We have a motion by Ben and a second by Ricky. All in favor of accepting general counsel's recommendation on this case, please say aye.
Aye.
Any opposed? Hearing none. Thank you, Jesse.
All right, we have a very brief rules update. We do have some new rules for mixed martial arts and some for boxing as well that will go into effect September 24th, just in a few weeks. Specifically, those were the waiver rules that we had looked at that better clarified when the commission would waive rules. It also aligned all of the MMA fouls with the unified rules of mixed martial arts through the ABC's rules. So that will help, I think, going forward with consistency. And to show an example of that, the ABC Commission did vote on some updates to their MMA rules at this past conference in August. We will not need to amend our MMA rules because we will already be able to implement those changes that they had without making any further rule amendments. They did specifically look mostly at scoring as part of theirs, really trying to look at adding damage and aggressiveness as part of the way that judges score. And our rule for judging already specifically defers back to it's a 10-point system that looks back at the recommendations from the ABC's unified rules. So we won't need to amend any of our rules as it relates to MMA. Now, we do have one thing to look at, though, for the commission to consider. The ABC Commission did update their unified rules for bare knuckle boxing. Specifically, they changed some of the rules related to hand wraps, and our rule would need to be updated there. Certainly, if someone wanted to use the updated rules before we did any type of rule amendments, we could waive our rule to allow that. But they, just to give an example, our specific rule says one wrap of tape around the thumb. The update after the ABC conference is called a G wrap, which changes a little bit how the gauze and the tape is wrapped around the thumb as part of it. It has an open palm, and it specifically gives examples in the rules as to what that would look like. So our rule is a little bit different than that. So if we wanted to update to align with the bare knuckle rule for ABC, we would need to amend our rule with that. And then there was also an updated foul added for bare knuckle boxing that an individual would not be able to essentially come at their opponent from a crouching position. That would be a foul. explained it at the commission as to why it would be a foul. We would just need to either add that or do the same thing we did with MMA, where we would essentially say for bare knuckle boxing, you can use the unified rules unless they are waived by the commission for this specific bout. But if the commission would like to update our rules to reflect those changes, or to make boxing or bare knuckle boxing similar to what we did with MMA, where we just default to the unified rules, we would have to set that for a rulemaking hearing.
Okay, yeah, I mean, I personally like the idea of aligning with the unified rules. One, it makes it easier, and I think there's a lot more eyes on it that way. I would like to hear a little bit more about the crouching rule, because does that doesn't just mean bending your knees, does it? Like, is it like touching your knee on the mat?
No, it's essentially, you're coming at them. I can actually read the exact language of it,
Okay.
if that helps. And so the updated language says, any combatant commits a foul if they're moving towards the opponent to strike from a crouching position with their head below the opponent's belt line. So I think it's more of a safety issue than necessarily an advantage, but I think that's kind of the intent, that if you are crouching down, it makes it harder for your opponent to strike you while you are moving forward towards them.
Yeah, I get that. Is that a current rule in traditional boxing? I think I saw that recently, that you couldn't bring your head below the belt line.
I would have to look at that. I don't think it was added to boxing, so if it's in there, it was in there previously.
Okay. Yeah, I'll make a motion to do it, to have a hearing to align with the unified rules for bare knuckle boxing.
You want to include boxing in that as well, just kind of clean up all of our rules. I don't think there's any chance the ABC, well, I shouldn't say chance, but any likelihood the ABC is looking at changing that, but we might as well, so that way we don't have to look at it in the future.
Yeah, I think that's a good idea personally. I'll make that motion.
I'll second it.
Thank you. We have a motion by Ben and a second by Corey to go ahead and work on rules to go with the unified rules for boxing as well as bare knuckles boxing. All those in favor, please say aye. Any opposed? Hearing none. Thank you. That'll give Jesse something to do. Thank you.
Yes, doesn't say. Certainly never a dull moment. I do know we have on the agenda, the next item is the open meetings presentation. We do this on an annual basis. We do have some new business as well, talking about the waiver of MMA rules. Would you prefer to have to move on the agenda to have that discussion, or would you like me to do this presentation first?
So just approve the agenda?
No, I'm sorry. I don't want to add any confusion, but the next item we have is the You Are My Sunshine Open Meetings presentation. It is a 47-slide presentation, but we do have individuals here to discuss the waiver of MMA rules for the Dirty Boxing Championship. If you want to take something out of order on the agenda, that is allowed, but otherwise, I can do this presentation, and then we can do theirs after, unless you have a preference.
Do you want me there so they can leave?
Yeah.
Let them go. Yeah, that's
Okay.
what I would think.
Sounds good.
Sounds good. So members, you've got on your iPad, starting with page 10, Dirty Boxing Championship, to be able to review their documents. Jesse will lead us, and then we'll be more than happy to have them introduce themselves, unless you want them to introduce themselves first. What would you prefer?
Do you want to, if you'd like to introduce yourselves first, that'd be great.
got to be red. There you go.
Sure. To the presiding commission, thank you for having us today. My name is Jacob Stern. I serve as general counsel to Dirty Boxing Championship, and we're joined by one of our other officers of the company who's on electronically, Malky. We're here today for consideration of having our rules approved in the state of Tennessee, and we appreciate the consideration in having us today.
Great. So we've had.
Hi, guys.
Sorry, go.
Sorry, I'll go back on mute.
Is Mr. Fair with you as well, or Ms. Fair?
No, just Malky.
Okay. Okay, perfect. So the commission has considered waivers before. I just wanted to make sure that we're looking at that. We did recently modify our rules slightly to better explain, when the commission could modify or consider waiving its provisions to allow a different set of rules. Specifically, we did look at increasing when that could happen to specifically allow the commission to approve a waiver of its rules to allow another rule set from a promoter, if it could be done in a way that doesn't pose a risk to the health, safety, or welfare of the individuals participating in the contest or event. And I do also want to make sure, and so I think you all have a copy of the rule set in your documents. It should be, what page is it?
It starts page 11 on your iPad.
So you have a copy of those rules, and I do want to make sure it says specifically in the rules that were provided, but the name is Dirty Boxing, but we'd be looking at it from a mixed martial arts promotion, and we'd be licensed as individuals under a mixed martial arts license for both the promotion as well as for the combatants as well. I think there's a couple things to point out specifically as it would look related to the waiver. For the first thing that we would need to look, it should be on that first page of it. The rules discuss the fighting area. It is smaller than what we typically approve for an MMA bout. This is a boxing ring that's 18 by 18. We typically look at something no less than 20 by 20 for MMA. Now for kickboxing, we do look at an 18 by 18 would be allowed, and it would be allowed for boxing, but I did want to make sure that you all were aware. For MMA, it's a little bit smaller. And then as it relates to chest protectors, we typically allow that for females in boxing, not in MMA. So we would have to look at considering our waiver for that. I'm not sure that, Jacob, do you have any female fighters in this specific event that you're looking for?
Not yet, but subject to change.
Okay. And the fighters do use an MMA type glove, so that is something that we're looking at. Again, it's consistent with MMA as it relates to that.
Okay.
And then obviously, though, as it relates to apparel, wearing shoes is not allowed typically in our MMA. But this is, again, with it being a hybrid without having submissions. That's where we'll be looking at a waiver there to allow the combatants to wear boxing shoes instead of being barefoot. And then the biggest waiver for our MMA rules specifically, we do allow when a fighter is downed, there are certain things that can occur. Obviously, if they go towards a submission, there's certain procedures for allowing striking while someone is downed. Where Dirty Boxing is a little bit different than our typical MMA is that when a fighter is downed, there can be strikes, but there's no submissions, there's no grappling, and the fighter who's on top can't be down as well. He has to be in a standing, or he or she has to be in a standing position to continue those strikes. Their rules specifically have some procedures for if that standing fighter ends up going down, that then the referee stands them both up. And certainly, Jacob, if I'm misstating anything, please correct me.
So far correct.
Okay. And again, if a fighter is down, unlike boxing, there's not an 8 count or there's not a count at all. They can continue striking, and the referee either could stop it, obviously, with a TKO. If the fighter was not defending themselves, the referee could stand them up, or that fighter could push them off and try to stand up.
I see the bullet point where it says authorized to allow ground and pound for 5 seconds, but then up above it says so long as punches continue to land, the fighter will be allowed to ground and pound.
Sure, those were just a draft copy we provided of little comments when we were making the rules originally. So the way it sits now is there is 5 seconds as long as activity is present. If there's no activity, then the ref has the discretion to either stand them up or if he sees, visibly something else going on, stop the fight overall.
So if you're ground and pounding,
And
you
then-
only get 5 seconds to ground and pound, or until you stop?
Correct.
Okay, 5 seconds.
Yeah, so if I can just jump in really quick. So the 5 seconds is where the fighter is in a standing position over the other fighter on the ground. He has 5 seconds to finish the fight. If, for whatever reason, the fighter on the ground is completely out, then the referee can stop the fight right away, does not need to get to the 5 seconds. If the fighter in the bottom position is defending, and he's not out, then after 5 seconds, the ref will stand them both up and restart the match again. So obviously the safety part is very important for us. So if a fighter is out, there will be no 5-second ground and pound. The ref has the discretion to stop the fight right away, similar to MMA.
Understood.
And then there are some changes in subsections 11, 12, and 14 as it relates to fouls and how judging and then stopping a contest under 11. I think the biggest areas where there are changes, obviously, with the stopping the contest, with boxing, there's a little bit different there, and MMA is a little bit different. I think the taking a knee and raising the hand above the head, obviously, a fighter is just specifically, essentially surrendering that, whether they're stopping and giving up. So we'd be able to use our rules for that. As it relates to judging, though, there are some differences, specifically since there are no submissions. The judges won't be looking at any techniques related to that. They'd be looking purely at striking. It's almost more like a boxing scoring, essentially, at that point, since there are some of the grappling items taken out. And then under fouls under 14, obviously the kicks being taken out, that's different than MMA. Takedowns, clinching, those would all be fouls in dirty boxing. Those are things typically, both in the unified rules and in our rules currently, those would be considered fouls, or not considered fouls, those would be allowed. But it's just a difference in terms of what's allowed. I think the last thing that is something for the commission to consider, you'll see it on subsection 16 and 17. For our MMA rules, we do allow up to 5 rounds. And I think when we've had this question come up before about extra rounds, I think it might have been Karate Combat, if I remember. I have to look back at my notes. But dirty boxing has a mechanism to allow 1 extra round. Essentially, if there is a draw at the end of the scheduled rounds, they can add an extra round to determine if someone could, win by a TKO at that point or a KO. It's only 1 extra round. Obviously, if it's still a draw at that point, it's a draw. But that is something that is a little bit different. I think previously when we had allowed a promoter to do the extra round, it was already in compliance because essentially it was adding an extra round. We just approved it as if it was a 5-round bout at that point. We did 3 + 1. We approved it as a 4-round. If they were doing 3 rounds, but they could go to that extra round, we just approved it as if it was 4. If it is a non-main event or non-title bout with the 3 rounds at 3 minutes, that typically would already align with our MMA rules. We could approve it basically for a 4-round bout at that point. Even if it doesn't go that round, it could go only 3. The only thing that would be different is if it is the main event or a title fight going to 5 rounds, our rules do say that we would approve up to 5 rounds for MMA. It's also what the unified rules of MMA say. But technically, this could go to a 6-round. I don't know how likely it is that you would have a draw at that point that would have to go to that extra round. I don't know if you all have any statistics that, if you've seen that already previously, but I do think when we previously had the event that had the ability to have an extra round, none of the bouts went to that extra round.
Yeah, MMA 5-round fights, it's 1 in 1,000 maybe.
Right. And I would also add that they're looking at 3-minute rounds, and even both under the unified rules and our rules where we look at specific minutes total, even if they went to a 6-round, it would still be below that threshold, even if it went to that full 3 minutes for that 6th round as well. But that is something that, the commission would need to consider waiving, and I wanted to bring that to your attention because that is something I think that's a little bit different than our current MMA approval. So if you all have any other questions, or was it Jacob or Matt, if there's anything else that you all wanted to.
Yeah. Yes, thank you so much. You actually explained the rule set better than any of us on our team. That was phenomenal. I appreciate that. I just want to clarify one thing on the clinch. So a Muay Thai clinch is actually in our rule set. It's, benefits of Muay Thai fighters. So as long as they're active, it wouldn't be necessarily considered a foul. However, if they're just hugging and grabbing, that would be considered a foul, and we would want there to be a point deduction after a warning from the referee. So similar in MMA, if you were to grab a cage, a ref would warn you, and then if you do it again, you get point deducted. For us, it would be if you're hugging the fighter, you would get the warning from the referee, and then he would go around and deduct a point to all the judges. Which, to clarify, that would be an underhook or an overhook. And you typically see that a lot in boxing matches where fighters, when they get tired or they don't want to really throw punches, they start to grab and the ref breaks them up. So that's what we really want to avoid, the hugging and the grabbing.
Yeah, it was actually a problem in one of the bare knuckle boxing fights. The guy who ended up winning, I believe, used that as a tactic to slow the other guy down and tire him out. Just 5 rounds of clinching.
Right. Commission members, do you all have any other questions? I've got 2 questions, unless you all don't have anything else. Do you all bring in your own referees who are familiar with the dirty boxing rules?
To our understanding, at least where we've operated already, we've had the rules from, the individuals in that state. I think Tennessee operates a little bit differently, correct?
So we could, obviously, and I guess kind of to back up as well, as this helps the commission. You all were sanctioned in Florida, or have been sanctioned in Florida, correct? So if there was an individual who is a referee sanctioned in Florida, it's likely we could we could license them here as well. So that is something I think that could be considered. We would just have to look to see if they meet all our licensing requirements. But I wasn't sure if you all planned on bringing in specific referees or okay.
The game plan was to bring in officials. Malky can correct me on that one, but I think that was the.
I need you on the record.
Oh, sorry.
I'm sorry. You're good, thank you.
Hello, my name's Matt Young. I'm working with Dirty Boxing on logistics and getting everything, but I think the game plan was we're going to use local MMA judges, but we're going to bring in officials from the outside that are qualified and have done the dirty boxing rules before. So, and a lot of our MMA judges have done UFC stuff, so they're all top shelf.
And then just related question: do you all bring doctors, or do you typically use local doctors?
Most likely local, but same applies.
Okay. I was just curious, not
No,
probably
sure.
as much
No,
of a concern.
of
but
course.
I was just curious. Those are the only questions I have. So, commission members, if you don't have any other questions, or there's nothing else from Dirty Boxing, you all could either I'll kind of outline just what you all would like to do on this. At this point, you could vote, or you need to make a motion and then vote either to waive the commission's rules and to allow Dirty Boxing to use their rule set, either in whole or in part. If there were things that you felt like was not safe or that the commission did not want to approve, you could look at that and potentially open up for discussion as well if there were specifics you had questions about. But waive the rules to allow the Dirty Boxing rules as they've been presented, or obviously not approve them would be the other option.
I don't see anything that I think would cause lack of safety for fighters any more than MMA. So I would make the motion to accept the rules as they stand.
I'll second that. Y'all have gone.
Ricky, can you turn your mic on red so we can hear you?
I'll never will forget that. Thank you. I don't even know what I was saying, but anyway, it sounded good. When you get my age, you forget. But y'all have gone the extra mile too for safety, and to me, it looks like everything else. This is safer than any other thing we're putting on. I went to the the bare hand thing, and it impressed. They had their stuff together, and it seems like that's what they're doing here. And they've gone by the rules. I mean, the shoes, I don't think that should be a problem. You can't kick, so that might give you
Correct.
better. But sounded good to me. Thank you.
Thank you as well.
Yes, sir.
So we have a motion by Ben and a second by Ricky to allow Dirty Boxing to follow their rules and waive ours as explained by our attorney. All those in favor, please say aye.
Aye.
I'm gonna say aye, but my light's not going on.
Yeah,
Two minutes.
aye.
2 minutes. All right. Any opposed? No. Thank you. All yours.
All right, thank you.
Thank you, guys. We appreciate the opportunity to present and definitely look forward to working with this commission.
Thank you. Thank you.
Thank you guys so much. We appreciate it. We're looking forward to October 30th. John Jones is coming in town. Mike Perry's coming in town. We're going to make it a fun night in Nashville. Dirty Boxing 4.
Thank you, and thank you for joining us virtually. Appreciate it. Members, Jesse's going to do the You Are My Sunshine presentation. This, of course, is something all members are trained on when you do your orientation, how to be transparent and always address everything on the open record. So we'll let Jesse proceed.
All right, and like I'd mentioned earlier, I think we've talked about this obviously during orientation. We try to do this on an annual basis as well. So, if you have any questions, feel free to stop me, but I will try to get through this quickly and explain it well. I think last time the PowerPoint wasn't working, so you all just had to listen to me. But we do these presentations for all of our boards to make sure that they're up to date on the Public Records Act and the Open Meetings Act. Again, this is just as a short disclaimer. We do try to provide this regularly. This is all kind of generalities, obviously, as it relates to the law. So if there are any specific questions or facts, those are things that we would want to discuss either with the commission specifically, or if you have questions about setting a meeting or our agenda, we will make sure to discuss those on an individual basis. So first we'll start with talking about the Public Records Act. When we look at, there's a pop-up on my screen, so see if I move that. We look at the Public Records Act, we're specifically looking at what types of information is a public record. Typically it's going to be any document, paper, letter, map, book, media, obviously, if you've taken photos, electronic data, processing files. Essentially, if it is something that can be put on a screen, shown on a screen, can be printed off, that's going to end up being a public record. There are some exclusions, certain things that are not included either as public records, either specifically by law, or they just don't fit into one of those categories. So we do have to look at, when we get requests for public records, we do have to look to see if it is something that is excluded as confidential, such as medical records typically are things that are going to be confidential, certain financial records, those types of documents. It's not included the specific devices or equipment where the records are stored. So obviously the records that you all have on your iPads, those become public records when we present them in the meeting. But the iPads themselves are not public records, so someone couldn't request to come in and see this specific iPad. If they wanted records that we showed it, we could make that available for them. Now we'll look at the Open Meetings Act. Generally, a meeting is any time there's going to be either one or more than one board member present. That could be a meeting. Chance meetings are not included. So if you all run into each other at the grocery store, it's not going to be a public meeting. But if you did decide to call each other and start talking about board business, that would technically be a meeting, and we would have had to go through all of the steps to make sure it was properly noticed and open to the public. So again, we're looking what types of things are considered meetings. It's going to be any type of meeting where there's board members getting together to talk about public policy or decisions. If board members were calling each other to talk about a complaint against a promoter, that would be board business. If you run into each other at the store, or even if you were to somehow talk to each other about the UT football game, that's not going to be necessarily board business. You're not making a decision. So that's something where it would fall outside the scope of being a meeting. That also would be excluded. But I'm surprised how well Vanderbilt's doing this year. They've been exciting. The goal of the Open Meetings Act is to promote openness and accountability. Again, really, we just don't want a situation where boards are conducting business outside of the scope of the public. So that, again, gets back to if the board was trying to make a decision on something, the goal is to have that obviously available for public viewing and comment on that type of decision. And this applies to all meetings of the board. They all are declared public meetings. There are some exceptions, though, and generally one of them we'll get into is if the board was being sued, for example. If someone filed a lawsuit against the board, it would be hard to have that discussion about what defenses are available if it's a public meeting, because obviously the other attorneys or other side could just sit there and listen to the whole thing. So those types of meetings are typically not open to the public. The Open Meetings Act, it does apply to any governing body, which includes this board. Again, going back to what is a meeting, it's any type of specific meeting of the governing body to make decisions or deliberate on public policy. It also doesn't include an on-site inspection of a project or program. So, this is just a good aside. Specifically for this board, we have obviously events that occur, and we do make every effort to make sure that board members try not to go to the same events, so that way we don't have to worry about someone accusing the board of being engaged in a meeting. But obviously, if you ran into each other at an event, it's fine to say hello to each other. You don't have to avoid each other, but typically, if we had a board member who goes to a fight, that's not necessarily a public meeting. Even if there's two members who are there, again, we try to separate so there's no impropriety where someone could say that they had the opportunity to discuss board business. But that doesn't necessarily mean that it's a board meeting just because two people happen to be at that same event. And again, it doesn't include any chance meetings. It has to be a situation where you all would be discussing specific board business. And it's also not a meeting, if two people got together, had lunch together. Again, we do typically try to avoid any sense that there could be impropriety, so we try to avoid, having instances where someone could see board members together and think they could be talking about board business. But it's not necessarily a meeting just because two people are together. Also, anytime we take a break from our meeting, it's also not a meeting as we go off the record. Typically, as long as we stop the recording, if there are breaks, we don't always. Sometimes we still have the recording going, but typically that would be no longer part of the meeting. And again, an executive session, if we're talking about a lawsuit or anything like that, that would not be a public meeting. Again, talking about the exception there. Let's see. Also, electronic media, we'll touch on this briefly, but electronic communications are also considered public meetings. I know we talk about this during orientation, specifically if the board is or if members of the board are emailing myself, or the executive director, or our staff, that's not a meeting if it's just one board member doing it. But there are concerns, if board members were emailing and other board members were on there, specifically talking about taking action against a licensee, for example. It's not necessarily, if you're emailing the executive director and asking for something to be put on the agenda, it's not a meeting. If it starts to get more specific, looking at, I think we need to discipline this person, for example. I think we need to shut these people down. That could be considered a meeting. Those are the types of things where there's action being taken. So we do be careful, or we want to be careful about that, I should say. Again, if you're emailing questions about the legal consequences of something or the legality of something, that wouldn't necessarily be a meeting. But just make sure that we're taking steps to make sure that any of those emails are not taking specific action outside of a board meeting. Let's see. We do have some changes that allow board members to participate in meetings electronically. If you cannot attend a meeting in person, try to let Roxana know as soon as possible, just so that way we can make arrangements for members to participate electronically if needed. We can have a quorum, even if someone wasn't able to participate. We don't have a quorum in person, but we could have a quorum because someone's able to call in. Let us know. We can try to make those arrangements. It does make it a little bit more difficult, just logistically, but from a legality standpoint, we can still have a meeting if needed, because we have someone who can participate electronically. And that would still be considered a board meeting, even if you have one or even all members electronic. If you all recall, there was a meeting that we had last year to discuss a waiver issue where all of us met electronically to discuss that. And that was properly noticed to the website. We went through all of our open meeting requirements for that. Let's see. We do also, there is a requirement that we allow members of the public to participate in our meetings, whether that's through public comments or showing up in person to view the meetings. We are required to give notice of our meetings, and that notice has to be reasonably in time. So we look to see how far it was. It has to be sufficient. Typically, we do that by posting it on our website. It's not something where we just announce it in the meeting to say the next meeting's on this date. We make sure that it's in writing, and then we post it to the website as well. Typically, we're looking to make sure that the notice reasonably describes the purpose of the meeting. It's sufficient in giving advance notice of the meeting, and then it must be posted and gives the location where the meeting will occur. Typically, we just do that through our internet postings. So we'll skip that. And again, we would look at all of the necessary facts to make sure that it's adequately posted, that there was sufficient notice, and that there was reasonable details given of the meeting. It's really a case-by-case situation. So when we had, for example, this meeting being postponed, we had to look to see when we posted the agenda. You heard Roxana specifically mention that when the original agenda was posted, when everything was listed online, that's the reason why we make those comments during the meeting and why it's listed on the agenda. Now, the effect of a violation of the Open Meetings Act can be costly. Specifically, if the board took a action that was found to be in violation of the Open Meetings Act, the first step would be that action would be null and void. So, for example, if the board had a meeting that was in violation of the Open Meetings Act, tried to revoke a promoter's license, that revocation wouldn't be lawful. But what can also be costly is someone could be entitled to, if they had to sue the board, they would be entitled to costs and attorney's fees with that action as well. So that is something to be aware of. Typically, the action could be cured if for some reason, the board said, hey, we want to revoke this promoter's license. They did that outside the scope of a meeting, then came onto the record and said, hey, we want to revoke this person's license, went through all those steps. You can cure it, but there are some concerns about if it was originally in violation of the Open Meetings Act, if they could still sue and be entitled to those attorney's fees. So really the rule of thumb is to make sure that we're doing everything in compliance with the Open Meetings Act. So if you ever have any questions about any actions or board business, you can always send an email to the executive director or myself, and we can make sure it gets on the agenda. So in a nutshell, the Open Meetings Act is designed to make all board business conducted in a way that's accessible to the public, and it applies to individual board members, acting specifically in their authority as well as the entire board. And say individual board members can't take action that would be in violation of the Open Meetings Act and then try to cure it by having the entire board vote on it. Again, a meeting is a gathering of the board. It has to be more than one board member. And then it also includes any regular, special, or emergency meetings of the board. And if you're concerned that anything violates the Open Meetings Act, obviously we would want to know as soon as possible, but any acts that are taken outside of an Open Meetings Act are typically null and void, and those can lead to costs of the litigation and attorney's fees against the board if someone were to sue the board for that violation. The last thing we have to discuss, we've also discussed this previously, but the 2015 case, the North Carolina Board of Dental Examiners versus the FTC. This was a lawsuit that arose out of the state of North Carolina. Generally, what was happening was the North Carolina Dental Board sent 47 cease and desist letters to individuals who were providing teeth whitening. Essentially, the board felt like they had jurisdiction over individuals who were doing teeth whitening. Those individuals disagreed. The FTC ended up suing the board, saying that the board acted outside of their scope. Just to kind of give maybe a more on-point example for this board, obviously we regulate unarmed combat. If for some reason people were conducting, fencing with swords, and the board said we want to regulate professional fencing, it's armed combat. They have, I can't remember what the specific sword is called in fencing, but that's armed combat at that point. If the board said we're going to send cease and desist letters to those people, even though it's not under our authority, we regulate combat sports as a combat sport. Because it's not unarmed combat, that would be outside of our scope of authority. That could lead to issues with our board. So this case, though, for North Carolina, it did go to the Supreme Court. The Supreme Court specifically said the board didn't have authority to regulate teeth whitening. They said it wasn't listed in their law or their authority to regulate them because it was not a dentist, essentially. And that state agencies simply are not able to continue to act, and government immunity didn't extend to that because it was outside the authority of the board. So that's something that we would have obviously concerns about if we were regulating unarmed combat. We would have government immunity. We start going outside of our scope of authority, we kind of lose some of that immunity. And essentially from that decision as well, there were some requirements or some direction to look specifically from the state to make sure that we're not conducting anti-competitive conduct, that we're specifically want to be promoting policy rather than parties' interests. Those are kind of the reason why the Supreme Court sided with the FTC. Tennessee ended up enacting a law 6 years after this case, which specifically said that we would have a supervising official who is looking at the acts of regulatory boards to make sure that they are acting in compliance with their authority. Our supervising official, and the individual normally watches our board meetings, but they look to ensure that the actions of the boards don't displace competition and consist with the policies of the board. But I think it's also important, as part of the Board of North Carolina case, there were some things that I think that board did wrong from the outset that are easy for us to avoid. One specifically, we always want to look to make sure that our actions are in compliance with our actual scope of authority. They obviously were outside of that. I think it was, there's some question as to whether or not someone doing teeth whitening is a dentist or not a dentist, but that was something that the Supreme Court said that they were acting outside of their scope of authority. So if there's ever questions about, regulating a combat sport, if it's within our authority, those are things that we should discuss. Another thing that was at issue, they didn't have any rules or policies specifically looking to define what teeth whitening was. Part of the reason why we have all of our rules, and we take the time to make sure that we're drafting them in a way that covers what we want it to cover, we want it to say what it's supposed to say, is so that way, one, not only does the public understand, the effects of the rule, but two, we again have stated authority of what we are regulating. If something was outside of our rules, such as for bare knuckle boxing, for example, bare knuckle boxing was outside of the scope of our rules for a while. Probably wouldn't have been legal to have bare knuckle boxing until we did rules because it would essentially violate the criminal law. But once we did that rulemaking and were able to promulgate the rules for it, it became legal and it was something within our authority at that point. So that's part of the reason why we specifically go through, all of those requirements with the rulemaking. We make sure that we're acting within our authority and that our stated policy for that. If any of our actions do fall outside of our stated policy and they require further review, our supervising official can make sure that the board acts in a way to either nullify that or veto or either approve or remand the action for further steps. So if for some reason we did something that was deemed outside of the board's authority, typically there are steps that we can take to make sure that we're acting in accordance with that before it gets to a point where it could lead to litigation or anything further. So that's it. I know it's a long presentation. We do it every year. And then obviously our new board member, he had a very quick version as well when he got his packet of board materials to discuss. But do you all have any questions specifically about this? Okay. All right. Well, that is it then for all of the items I have on the agenda.
Thank you, Jesse. Thank you so much. Members, before we adjourn, anything else that you have, questions, anything at all?
Can we get our teeth white?
Oh, I guess we should. Just to add, we were scheduled initially for a formal hearing for our meeting previously. Obviously, because this meeting was rescheduled, we wouldn't have been able to set that for today with proper notice for that individual. So we actually have 2 hearings set for the next meeting. Those are set for 3. Both of them should go relatively quickly, but I would anticipate we'll probably end that meeting closer to 4 or 4:30.
Thank you, Jesse. And our next meeting is December 8th. So when I send everyone their email a week ahead of time, I'll remind us of the hearing because that'll be a little bit longer. If there's nothing else, as I mentioned in the beginning, we want to make sure to give members of the public either here or participating virtually. Dana, unless you see a raised hand, I think we've got everyone that's on is from our team, if I'm not mistaken. Any messages or anyone that needs to ask questions?
No.
All right, thank you. Having no questions or concerns from the public, I would entertain a motion to adjourn the meeting.
I'll make that motion.
We have a motion by Ben and a second by Ricky, and I've got us finishing the meeting at 2:45, I believe. Thank you, 2:52. Thank you very much, members, for all that you do. We are adjourned.